All right. Hello, everybody. How's it going? This is Immigration Attorney Moumita. I'm coming to you live to talk to you about immigration, to see the questions that may be on your mind today. Thank you so much for joining me. My name is Moumita Rahman, and I'm an immigration attorney. I've been practicing immigration law for the past 15 years, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. And I know that times are scary right now. Times are really, even more tougher than normal, even for people who already have green cards. So let's go ahead and talk about your questions and your concerns. I know that the number one topic on everyone's mind is always travel, which I will get into a little bit later. So let's talk about the fact about what is going to happen to your case with your I-485 if you and your spouse have filed, but your marriage is not working out. What is that going to do to your case? Well, I do want to let you know that these days we have to be a little bit more careful. We have to be more careful, and we have to try to not get that I-485 denied more than ever, because these days, a denied I-485 is resulting in issuances of notices to appear in court, which we're seeing more and more and more. And this is something that can be problematic, of course, because it's very, very scary to receive that letter saying that you have to report to court, that you're no longer allowed to be in the US, that you may be removable from the US, right? So let's talk about what will happen if you do receive a notice to appear. What are the basics of what to expect in court? We were having a lot of clients come to us who may not have had an NTA or notice to appear in court before, but now they're getting it because of denied cases. And what can you expect? Because we have a client who's really, she's not the only one. We've had multiple clients be very, very afraid that if you go to court for your hearing date, that ICE is going to be waiting for you to arrest you, right? So is this a legitimate concern? Is this a valid concern that you need to be worried about? And what can you do to protect yourself? Well, this is the first thing. Number one, if you are somebody without any sort of criminal history and you receive a notice to appear in court, generally speaking, I would say that this is not really something that you should worry about insofar as ICE is not typically going to be waiting for you in court, because the whole point of ICE is immigration and customs enforcement, right? What they are responsible for is placing people into removal proceedings in order to, allegedly remove them from the U.S. because they're in violation of immigration law. So their whole goal is to put people into proceedings and then to get them removed from the U.S. If you have already been placed into proceedings, then they don't really have to do that. So if you receive a court hearing notice, you don't have any criminal issues, typically speaking, ICE is not going to be waiting for you at court, right? Because you have a case in front of the judge at this point. You have the opportunity to prove to the judge, to the immigration judge, that you should not be removed from the US, that you qualify for some sort of relief, and that you should be allowed to stay, right? So you still have that chance. And while we speak, we still at the very least have this bit of due process left in our systems. So if you have an upcoming hearing date in immigration court, you don't have any criminal issues, I would say that you should not be worried about ICE coming to snatch you there, okay? Now, if you have any sort of criminal issue, that's where things can get a little bit trickier, because as you may or may not know, the Lake and Riley Act, which was signed into law in January, does call for mandatory detention of persons committing committing or being accused of or charged with any sort of theft-related offense, or any sort of offense that causes physical harm to a law enforcement officer. And that is where things get a little bit trickier. And this is where we are seeing people get picked up for shoplifting, simple shoplifting, things like that. And if you get arrested for shoplifting after January 20th, and this is something that is going to increase that likelihood of getting detained. And if you do get detained for something like that, the unfortunate news is that you may not be eligible for bond to be released, and then basically you are going to be at a higher risk. And in those instances where people, if you have some sort of active charge or some charge post January 20th that pertains to the Lake and Riley Act, that's when you really, you should be speaking to a lawyer regardless, but that's where it can be a little bit more hectic, right? Now, what happens if you have a criminal conviction from before and then you get a notice to appear? Well, what I would wager to say is that we're not seeing people get picked up for charges from before, and we have yet to see what will happen. But Lake and Riley is not meant to be retroactive. Okay, it's not meant to be. Laws that are passed are not usually retroactively applied. Okay, now if you do receive a notice to appear and because your I-485 was denied, the number one thing that you need to do is you need to obtain the services of an immigration lawyer, because even if you're not detained, if you are in removal proceedings, the chances of you being able to get out and to be able to prove your case to the judge are very difficult by yourself. Now, I want to bring you back to the topic of what happens if you filed a marriage case together with a spouse before, and that got denied for whatever reason. Maybe your spouse withdrew the I-130, or they didn't show up to the interview, or you just didn't get approved, right? If you just didn't get approved, now you have notice to appear, and you now need to figure out what to do in court because you may no longer be with your spouse. So what hope do you have? And I want to talk to you about the VAWA self-petition. I know you heard me talk about it before, but if you were suffering in your marriage, and if your spouse refused to show up to the interview, they didn't give you the evidence you needed to respond to a request for evidence, they didn't want to cooperate, they started messing up answers on purpose at the interview, or they withdraw the I-130 at the interview, to me, these are manipulation tactics. And usually when a U.S. citizen spouse does these sort of things at that point when you are trying to get your case approved, there's usually a lot more things going on. So usually what I see with clients is that they'll have suffered lots of other abusive measures, a lot of other control tactics. Maybe your spouse took away your EAD card. Maybe your spouse wouldn't let you talk to your friends. Maybe your spouse kept threatening divorce, or they keep threatening immigration on you. And now if you're in that position where your case is denied and you're in court, do you still have any hope? And the answer is yes. There are two potential options if you're in court and you have suffered a abusive marriage like that. And I just want to point out again that you do not need to have physical abuse to file this case, okay? Emotional abuse counts underneath the law. Emotional abuse is called extreme cruelty in the immigration law, and this counts. And extreme cruelty is basically any pattern of actions by your spouse that are basically controlling your life, right? That's really what it boils down to. Was your spouse trying to exert control over your life? And if that's the case and they have harmed you as a result, even if it's psychologically, then this may count for VAWA, okay? So if you do have a denied I-485, you end up in court right now, and you know that you have suffered in your marriage, and you're basically in the position that you're in because of what your spouse did to you, then VAWA may be an option for you. And now people ask, can you still file for VAWA if you're no longer married to your spouse? And the answer is that yes, maybe, and it depends on when your marriage to your U.S. citizen spouse ended. If your marriage to your U.S. citizen spouse ended within the past 2 years, then you may still be able to file for VAWA. If your marriage is if your divorce is more than 2 years old, then you may not be eligible for VAWA. However, we can look at other types of cases, okay? So if you end up in court, and because your I-485 with your spouse was denied, you may still be able to file VAWA even if you're in court. Now, the strategy that we have had in our firm over the past many years is if a client ends up in court and we file for VAWA, we have frequently been able to get the cases dismissed with the consent of DHS attorneys, because they opted to to apply prosecutorial discretion in getting the case dismissed. So a lot of our VAWA clients have had their removal proceedings dismissed in court, so they don't even have to worry about it. But what happens if you can't get it dismissed? Well, look, you still have to show up to court. And basically what happens is you show up to court, you can let the judge know that you're filing for VAWA, and sometimes the judge will give you more time. And if the judge doesn't give you more time, then you may be eligible for something called VAWA cancellation of removal in court, for which it requires for you to have been here for at least 3 years, okay? So that's one of the number one things. So I'm just pointing out all these things to you. So if you are in that position where you receive a notice to appear, I just want you to know that all hope is not lost, okay? Now, there are options, and if your divorce with your spouse ended more than 2 years ago, or you had a finding of marriage fraud in your case, what other options may you have? Well, we can look at the T visa. The T visa is one of my favorite cases to work on, in addition to VAWA. I really, really love these two cases. I love a lot of my cases, but I really particularly like the T visa case because of the fact that there's not a lot of attorneys that do them, and there's not a lot of Not a lot of people who know even about this as an option. And I call it this miracle visa. So let's take for that example, you being in that abusive relationship and your spouse caused your I-485 to get denied. But you're no longer eligible for VAWA because your divorce happened more than 2 years ago, so you missed your filing deadline, or maybe you never had a shared residence with your spouse. Well, what I want to ask you is, if during the course of this marriage, your spouse forced you to work, right? We have many ways that this happens. Sometimes your spouse, your US citizen spouse, might treat you like a servant. Sometimes they'll tell you they brought you over or they married you so you could take care of them, right? You have to do all the cooking from 5 a.m. until 10 p.m. at night. You got to cater to their needs, clean everything according to the way that they say, right? Sometimes they will send you out to do work and then take all of your wages, right? They force you to watch, other kids. Like, there's a lot of things that can happen. But if your spouse essentially treated you like a servant and you don't necessarily qualify for VAWA, then the T visa may also be an option, okay? And it's the same process. If you end up with a notice to appear in court, we can let the judge know that you're doing this, ask for some more time, and just basically see where that goes, okay? All right, guys, let's go ahead and answer some questions. Hello, Emmanuel's asking, hello, how safe is our T visa applicants under this administration? Should a person pursue an additional petition if they can? Family-sponsored green card from Emmanuel. Emmanuel, thank you for your question. Now, it's a big concern of everyone's right now, like, how safe are you going to be even if you file an application? What I can tell you is that the T visa applicants are actually to me, they're even a little bit more protected, because there are provisions written inside the federal law that says if you are complying with law enforcement, right, ICE can't just remove you. ICE can't interfere in that. They have to internally deconflict to make sure that, like, them trying to place you in proceedings or to remove you does not interfere with other law enforcement applications. And if you're out of status, if you have a T visa file, that's great. Filing a family petition is not necessarily going to make you much more safer than the T visa application that you, okay? I hope that helps. KK, thank you. Please reach out to our office. I know that you're concerned about the time length of your case. Unfortunately, the way that it's working with immigration is that anyone filing or working or trying to file an immigration case right now, you guys need to be prepared for the unexpected. Since the beginning of this year, we have dealt with multiple setbacks because of USCIS. They have changed the form additions on us with no notice, which now we have notice, but we've had to redo all of our cases for the form updates. They would no longer take I-485s without a medical exam starting in December. And there's just lots of updates that they're giving us with very little time to prepare. So it's causing everything to take longer. And you know what, guys? This is actually their intention. Immigration is going to do whatever they can to try to delay the process, to make it more difficult to file. And the most important thing is that you just be working with somebody that is actually trying to get your case filed and is keeping up with these changes. So even if it does take a little bit longer, the good news is, KK, that your case is still being worked on and we are diligently trying to get everything filed, okay? But I know it's frustrating, and I apologize for that. Okay, let's see what questions I have. Desde Caspe. Hola, abogada, ¿en qué tiempo llega un permiso de trabajo por VAWA y a usted de estatus por hijo abusivo? Caspe, este permiso va a tardar más o menos 6 meses a 8 meses. Después, después enviarlo a la aplicación, ¿ok? 6 a 8 meses, a veces 10 meses, ¿ok? Okay. Ohana's asking, my husband got approved, but since we didn't pay, it got closed. Can it be reopened, or do I have to reapply? Ohana, I'm assuming that you're talking about the I-130 with NBC. If you received an email saying that your I-130 has been sent back for revocation because of inactivity on your case, you can sometimes ask NBC to reinstate your I-130 because, for whatever reason you failed to keep up with the updates. And if they usually respond back within a few months about whether they're going to approve your request for reinstatement or not. And if they deny, then you can basically, you would have to refile at that point. Okay. Let's see. Alita Light, I have a VAWA filed with you guys. I've got a prima facie now twice, but it's expiring in 4 days. Am I in danger while I wait? Alina, even though the VAWA prima facie itself is mostly used to show that you have you're basically prima facie eligible for a lot of benefits. It doesn't give you the deferred action necessarily, so it's not going to put you in much more danger. And USCIS has been delayed. They're not really sending out the renewals of the prima facie, I guess, quickly, and they only give it for like short periods of time. But hopefully, since your case was filed in 2023, you still have a bit of time to wait, Alina. But as long as you have your EAD, to me, that makes me feel a lot more comfortable. Okay. All right. Doe-eyed little thing. Hi, dear Moumita. It's been 36 months since I filed for VAWA. Still no news. Can USCIS still ask for an RFE from your experience? Doe-eyed thing. Yes, absolutely. If you filed your VAWA, just because you haven't, yet received an RFE, doesn't mean that you will. Now, here's my little secret. Here's a little inside information. The processing time that USCIS says on a case doesn't necessarily mean that's when exactly you will get a decision on your case, but rather sometimes it may mean like that's how long it takes to get your actual RFE, because let's say they say that the processing time for VAWAs is 48 months or 36 months, right? What that means is by month 36, they expect your case to reach the officer's desk, so the officer can start reading your case and decide and make a decision on whether or not they're going to approve. So really the processing time is really more the estimated time length it's going to take to actually get your case to an officer. And it's at that point where the officer might be taking a look at your case to see whether or not they need to give an RFE for whatever insufficient evidence that or whatever reason they think. Okay. And I just want to point out to you guys, we've been getting some RFEs, and I've noticed some trends. A lot of times, I just want to point out, like, this has been the case since before. You might get a request for evidence on your case for things you already sent in. It happens a lot more than you realize. Because why does that happen? Because the immigration officers are quickly going through cases. There's not a lot of immigration officers, and I do want to point out that this is another reason that's going to cause the processing times to again increase, because a lot of USCIS officers are kind of being forced out of their job. They're being asked to do early retirement, or they're being forced to come back to the office 5 days a week when they can't really anymore. So a lot of officers are actually quitting their jobs. So, if you're a good officer and you're watching, I'm sorry about that. But so it could still increase a lot of time. Okay. All right, let's see what other I have. Who's better to ask for supplement B, for a U visa prosecutor or police from Matresh? Matresh can be either. It just depends on the jurisdiction. I'm a New Zealander marrying a U.S. citizen. Can I leave the country for holiday before lodging the marriage? From Monique. Monique, you could, but then it just raises questions about your intention when you return to the U.S. You have to be really, really careful about making a misrepresentation about your intention to be married and to stay here in the U.S. when you come back. Okay. Thank you for the follows, guys. Are they strict with updating addresses in the system from Janet Bananas? Yes. So they're not, well, they've never been strict before, but they are planning to use people's failure to file address updates as a reason to get them in trouble. So if you have filed an application, you need to make sure that you are updating your address with USCIS, and per the law, you are required to update your address within 10 days of moving. And even though it's been not something that's really been enforced, it's not something that people have been punished for in the past, they may definitely start to hold that against you going forward. So if you are a non-citizen, even if you have a green card, if you are a non-citizen, make sure you file your change of address within 10 days if you move, okay? All right, guys. So that's all the time that I have for today. Thank you for joining me. Again, my name is Moumita Rahman. You can give us a call, 212-248-7907 if you want to do a case evaluation about your situation, okay? And even though we don't work with all types of cases, if we can't work with you, we may have a referral for somebody else that can help. However, you can just give us a call, 212-248-7907. Thank you and have a good night and God bless.